Hi, good afternoon, everyone. Thank you for being here in this breakout session where we are going to focus on the role of the Title IX coordinator and investigators. I think I heard someone ask a question about the slide decks. They are going to be made available. They'll be distributed out, and I see in the chat that the Board of Regents has confirmed that, so you'll have these as a resource with you. So I'm going to let Lexi drive the computer because I break every piece of technology that I touch.
All right. I think we should be good to go. If you guys can't see this. Okay, yep. So I guess if you're not speaking and you'll go ahead and mute your mic, that should get rid of some of that echo. But otherwise, if you can't see this slide deck, let us know in the chat and we'll see if we can scramble. But in the meantime, I think we should be ready to go.
Yep. Okay, so we covered a lot of information this morning about the federally mandated grievance procedure for sexual harassment under Title IX, under that narrow definition. We covered at a pretty high level the requirements of the Uniform Board of Regents policy as well, which is of course much broader than just Title IX sexual harassment, but encompasses all sorts of power-based violence, whether it is sexual in nature or gender motivated or not. We're going to use this opportunity this afternoon to dive a little bit deeper into your roles specifically as Title IX coordinators and investigators. We want this to be, it's a slightly smaller crowd, so we're hopeful that we're going to leave some time for questions and answers as well. And we want this to be a little bit more conversational also and a little bit more interactive to the extent it can be. We're sorry that we can't be with you in person. I think that's probably the safest choice you have made, but still unfortunate. We wish we could be there in Baton Rouge with you all and around the state of Louisiana. There is going to be some repetition of information, and that's to the good. The concepts that we repeat are really, really important to internalize. And I don't know about all of you, but it helps me to hear things a few times, a few different ways to really reinforce and reemphasize those high level kinds of things. So with that, let's get going. Oops. Okay. So first, let's talk about our foundational considerations, the general overview of this entire process. What is a Title IX coordinator's role? We've gotten requests to turn on auto captions. I'm hopeful someone in the Board of Regents office can help us with that because I don't think we have that capability to turn on auto captions. I apologize. We want to take you through just foundational considerations to sort of ground us as we go through the next couple of hours and the steps in this process, decision points along the way, and then the substance of what we need to do at each point. Certainly the first thing any Title IX coordinator needs to do is assess the report that you're getting. Are you looking at a report of power-based violence at all? It's a pretty broad definition, so chances are good that you very well might be. You want to have your initial intake meeting with the complainant and have a conversation. Go ahead and get your facts, get the allegations, get an understanding of what is underlying this complaint. And then the first thing you're going to do after that, before you put it into a process or an adjudicative process, is that you want to offer supportive measures to a complainant and to a reporter, if different from the complainant. As we heard this morning, Title IX sexual harassment and power-based violence affects more than just the alleged victim and the alleged perpetrator, can affect other members of the campus community as well. We're going to talk about very significant notice requirements as well. And then we're going to talk about sort of a threshold foundational decision that you as Title IX coordinators need to make. And just about everything you do after this point is going to be inflected by this one decision. Is this a claim of sexual harassment under Title IX? Does it meet the definition of sexual harassment under Title IX, or does it not? you're going to need to make that threshold determination to know which process you're going to put this complaint through. If it's Title IX sexual harassment, it's got to go through the Title IX process, no exceptions. If it's not a Title IX claim of sexual harassment, then it's got to go under your overarching umbrella policy that you as institutions will individually develop while keeping in mind the Board of Regents policy and best practice surrounding investigation and adjudication of power-based violence complaints. And then either way, you're moving towards investigation, adjudication, and potentially an appeal. Now, the one thing, and I know that I am, to use just a colloquial expression, I'm preaching to the choir here. This is work that you do every day, but this work requires a unique amount of emotional intelligence and discretion and sensitivity. These processes involve human beings, and they involve human beings who have potentially undergone a really traumatic event. It is traumatic to experience power-based violence or sexual harassment. It can also be really traumatic to be accused of it. You know, I can see a respondent being worried like, oh my God, my life is going to be ruined because of this allegation. And now I've got to devote all of my energy, all of my cognitive bandwidth to this rather than anything else. So everyone is going to be in a heightened emotional state. Everyone is going to be very aware of some really significant consequences and implications of being involved in this process on either end of it. So as you approach this process and as you approach the people involved, both parties, witnesses, members of the campus community that you need to loop in, keeping that emotional intelligence front of mind is going to be so critical. That will help you support your students, support your campus community, and just as importantly, it's going to help with the truth-seeking function that you have as Title IX coordinators to get to the bottom of what happened and address it appropriately. So here's a little piece of repetition that bears repeating under Title IX. A recipient, that means all of you, colleges and universities, a recipient with actual knowledge of sexual harassment in an education program or activity of the recipient, the institution, against a person in the United States must respond promptly and in a manner that is not deliberately indifferent. We are going to spend a minute unpacking that a little bit more than we did this morning, but this is sort of your threshold jurisdictional statement as to whether you're going to funnel a complaint into your Title IX grievance process, or if you're going to funnel it into your other grievance process that you developed to address other forms of power-based violence. Now, the alleged sexual harassment to be actionable under the Title IX grievance process needs to involve conduct that occurred under an education program or activity receiving federal funds. Now, what does that mean? It essentially means all of the operations of your school, of your institution, locations, events, circumstances over which the school exercises substantial control over both the respondent and the circumstances in which the harassment occurs. Now, obviously, that is going to include misconduct that occurs on campus, such as in one of your classrooms or one of your laboratories, but it also includes misconduct that occurs within off-campus school activities and misconduct that occurs at off-campus private property that is controlled by a student organization officially recognized by the school, such as a fraternity or a sorority. So all of those Greek houses, the Title IX jurisdiction extends there. Certainly in your on-campus housing, in your dorms, it's going to extend there. In your offices, it's going to extend there as well. There is, however, a geographical limitation. The sexual harassment must have been perpetrated in the United States for it to be actionable under the Title IX grievance process. So your study abroad programs, if it happens there, It's not subject to the Title IX grievance process. That doesn't mean you have to ignore it. You can handle it under your umbrella power-based violence process if you wish, but it's not going to be a Title IX matter. And just FYI, the DOE has taken a very literal interpretation of the statutory language. So when they mean in the United States, if your feet are outside of the United States, Title IX and the regulations regarding sexual harassment do not reach you. So for some hypotheticals, where are we responsible to implement and pursue our Title IX process? Where are we not? University sanctioned off-campus activities. Let's say you've got a sporting event at a lake. It's not on any campus, but it's clearly an institution-sponsored activity. That's going to fall within this jurisdiction. Fraternity houses, that's clearly going to fall under your jurisdiction. Now, what about a fraternity affiliated party that occurs at a member's private residence? That gets a little bit grayer. That's a little bit wonkier. The regulatory commentary says that it depends on whether the school exercises substantial control over the respondent and the context in which the harassment occurs at the party, or whether the circumstances could otherwise be determined to have been a part of the school's operations. So is this a sponsored fraternity party that the school recognizes? That might be our issue. That might be part of our jurisdiction. Is it a couple of fraternity brothers or sorority sisters have a friend who has a private apartment and they just decide to have a get together on their own as college students do? That might not be under our jurisdictional program. Study abroad programs, like I mentioned, those are not in the United States. So if you're not in the United States, it does not fall under these sexual harassment regulations for Title IX. There are 3 categories of misconduct that meet the regulatory definition. And again, we want to repeat these because it's really important, because it goes to this very threshold and really important initial determination that U.S. Title IX coordinators will make as to whether to funnel a complaint through the Title IX formal grievance process or through the uniform policies power-based violence grievance process. So the first is colloquially referred to as quid pro quo harassment, and only employees can commit quid pro quo harassment. And that is when an employee conditions the provision of an aid, benefit, or service of the institution on an individual's participation in unwelcome sexual conduct. So fully consensual voluntary relationships, that's not going to fall into this category. There is that unwelcomeness standard. Now, please note that the US DOE interprets this broadly so that the quid pro quo nature of the harassment can be implied from the circumstances, such as when there is a power differential between a professor and a student receiving a grade in that professor's class. That can be an instance of quid pro quo sexual harassment if a professor says to a student, I'll only give you an A if you sleep with me. Or if you have a professor with a graduate student that they're working with and they condition moving through a graduate program on unwelcome sexual conduct. That would be considered quid pro quo sexual harassment. The next category is sexual assault, and that includes dating violence, domestic violence, and stalking, as well as those terms are defined in the Clery Act and the Violence Against Women Act. You should already probably be very familiar with those 2 statutes and those definitions as well, since our colleges and universities have been living with those definitions for quite some time. Now, sexual assault includes a lot of types of physical sexual violence. The other 3, sexual assault, dating violence, domestic violence, and stalking, include lots of types of conduct that are not inherently sexual or gender motivated in nature. So keep that in mind, that there doesn't necessarily need to be this sexual element. And lastly, we have a catch-all, which I refer to in shorthand as sort of hostile environment, when there is unwelcome conduct determined by a reasonable person, and that reasonable person is sort of this mythical creature in law, but we still refer to that person. Unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. This is a very high standard. It is a standard borrowed from the elements of a student-on-student sexual harassment claim under the Davis case, which is sort of a seminal case in Title IX jurisprudence. For the misconduct to meet this category, it's got to meet all three of these requirements. It's got to be severe and pervasive and objectively offensive. And it's got to rise to the level of effectively denying a person's equal access to your programming. A lot of student misconduct and sexual misconduct that schools have traditionally considered to be sexual harassment prior to these regulations, and that regular people out in the world, when they refer to sexual harassment, is no longer going to meet this regulatory definition because it doesn't fit within any of these categories and it doesn't meet this high standard. But if you do have behavior that doesn't meet this high standard, it may very well meet the standard for power-based violence to be addressed through your institution's power-based violence policy. For instance, a lot of student verbal harassment is not going to fall with any of these categories. Students can't, by definition, commit quid pro quo harassment. Verbal harassment is likely not going to rise to the level of sexual assault, dating violence, domestic violence, or stalking. I suppose it could meet the definition of stalking if you had some other elements there. But typically, verbal harassment isn't going to be so severe that it would meet these definitions. And if it does meet the definition, it would have to be under that Davis standard. But fortunately, you as institutions have the ability to build out your policies. You have this very robust state statute and uniform policy that spells out how broad power-based violence is to be considered, and you do have the power to address it there. Now, for your institution to have responsibility under Title IX and the Title IX grievance process to respond to sexual harassment under that Title IX regulatory definition, you need to have actual knowledge. Now, actual knowledge means notice of sexual harassment or allegations of sexual harassment. And again, we're using that very narrow definition under the Title IX regulations of sexual harassment. Notice of that to the Title IX coordinator or any official of the institution who has the authority to institute corrective measures on behalf of that institution. The regs and the commentary tell us that imputation of knowledge based solely on vicarious liability or constructive knowledge is insufficient to constitute actual knowledge. So you knew or should have known kind of standard, that doesn't apply here. The standard is not met when the only official of the institution with actual knowledge is also the respondent. So the person who did it, if that's the only person that knows that they did it, that does not impute knowledge, even if that person is the Title IX coordinator or someone with the power to institute corrective measures. And the mere ability or obligation to report sexual harassment or to inform a student about how to report sexual harassment or having been trained to do so does not qualify an individual as one who has the authority to institute corrective measures on behalf of the recipient. So this is a lot of words to say that when it comes to sexual harassment as defined narrowly under the federal regulations under Title IX, institutions have an obligation to respond only when they have actual knowledge. That being said, you have a much broader state law that speaks to power-based violence. And I can't think of an instance of sexual harassment under Title IX that isn't also power-based violence and that wouldn't fall within the jurisdictional considerations. You have a state law that requires every single employee, with some very narrow exceptions, to report incidents of power-based violence. So while this is a safe harbor when it comes to actual knowledge under the Title IX regulatory definitions, you have state law requirements that far exceed this requirement. So at the end of the day, report, 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 and report some more. We have some definitions that we're going to continue to use throughout this breakout session. And, you know, the terminology, we spent some time on the terminology, not just because the regs, the Title IX regs use this terminology, but because I think the regs are going to something, like they're making a point. And if you read the Title IX regulations on sexual misconduct and you read the 2,000 plus pages of commentary, there are a few themes that emerged from me, from my perspective. One was a strong emphasis on robust due process protections that were mirrored on both sides of the equation. And another theme that really emerged for me is a very strong emphasis on the presumption of innocence, unless and until you go through this very complex Byzantine process to get to a determination of responsibility. And that emphasis on a presumption of innocence, I think, gets us to using words like complainant rather than alleged victim, and respondent rather than alleged perpetrator or even accused. It is much more sanitized clinical language that takes a step back from even putting the thought in anyone's head that someone could actually be a victim. We're not using that word anymore. We're not using perpetrator anymore. We're using this very clinical sanitized language. So all that to say, the complainant is the alleged victim, not necessarily the person who reports or complains of sexual harassment, but someone who is actually on the receiving end of it. And though any person could theoretically be a complainant, as a practical matter, it's going to be the student the overwhelming majority of the time. It will be the person who's on the receiving end or who believes they are on the receiving end who will be reaching out looking for some kind of corrective action. Respondent is now an individual who has been reported to be the perpetrator of conduct that could constitute sexual harassment. And throughout, we're going to be referring to complainants and respondents, not victims and perpetrators, not even alleged victims or alleged perpetrators. So as part of your Title IX grievance process and your basic requirements, the Title IX coordinator, investigator, and decision maker, and any person designated to facilitate an informal resolution cannot have a conflict of interest or bias, either for or against complainants or respondents or individual parties. There are some key roles in this formal grievance process. Each one has a role to play. Those roles stay relatively separate. And if there was a third theme that was to emerge from the Title IX regulations and the 2,000 plus pages of commentary, it's that everyone involved in this process is supposed to be as much of a blank slate as possible. And this is just my commentary and my opinion here. I believe that there was an impression and a perception that the protections against sexual misconduct had swung too far in one direction of protection and didn't offer enough due process to the other side of the equation. And these regulations were very much adopted in response to that, to sort of correct what was perceived to be an imbalance of emphasis. I will leave it to you all to decide whether or not they struck the right balance or if they went too far in one direction or another. But that's, I think, that one driving force behind these regulations was to correct a perceived imbalance. And because of that, there is repetition over and over and over in the regs that say that everyone who is involved in implementing this process in an institution has got to be free of conflict of interest and free of bias. No assumptions that alleged victims or complainants tell the truth. No assumptions that respondents lie. No assumption that girls are more truthful than boys or boys are more truthful than girls, or non-binary students or trans students or gay and LGBTQ students are more or less credible. We are supposed to come to this with as much of a blank slate as we can. Now, your formal complaint under your Title IX grievance process is going to be, it has a meaning under law, and that is the document that is filed by the complainant or signed by you as a Title IX coordinator that alleges sexual harassment against a respondent and requests that the institution investigate the allegation. Now, at the time of the filing of a formal complaint, the complainant has to be participating or attempting to participate in the education program or activity of your institution. In addition, before I move on, let's break that down a little bit. So a formal complaint is a document. So it's got to be written. And if complainants need assistance reducing a complaint to writing, we will provide that assistance to them. It can either be filed by the complainant or signed by a Title IX coordinator. So if you as a Title IX coordinator believe that you have received a report of potential sexual harassment or Title IX that needs to go through the investigation and adjudication process, even if the complainant doesn't want to file a complaint, you do have the authority to start that process. It has to allege sexual harassment as that term is defined by the Title IX regulations, and it has to request an investigation. So there is no investigation without a formal complaint, and there is no formal complaint without an investigation, essentially. If a complainant is just looking for supportive measures, they just want counseling. If they just want a little extra time in class so they can get their head together, they just want to feel safe. They don't need to go through the complaint process to get those kinds of supportive measures. But if a complaint is filed, that means an investigation is happening. So a formal complaint can be filed with you as a Title IX coordinator in several ways. The regs require be filed in person, by mail, by electronic mail, by using the contact information for the Title IX coordinator should be prominently visible on an institution's website at your email address and your contact information. And if you want to designate other methods to intake Title IX complaints, your institution is perfectly free to do that. I know of some institutions that have these online fillable fields, and it automatically goes to the Title IX coordinator. There's all kinds of ways to do this, and that is completely up to you as institutions, but at a minimum, you've got to allow for filing by mail, electronic mail, or in person.
Great. So now we're going to talk, switching gears from emphasis on the process itself to talking about some of the key people and the roles that they play on, in the scheme of campus investigations and adjudications. We'll start with the Title IX coordinator, who is an integral part of a school's sort of system-wide approach to ensuring non-discrimination and to preventing and addressing sexual misconduct, power-based violence, and narrowly defined sexual harassment when it occurs. That title is descriptive. A coordinator, as Dan said in our morning plenary earlier, coordinates. This person is in charge of shepherding the process from cradle to grave. There is no point during an investigation, during an intake, an investigation, an adjudication, an appeal, or that post-appeal period at which a Title IX coordinator lets go of this process. This person is a Jack or a Jill of all trades, wears a bunch of different hats, coordinates and liaises with numerous different entities, organizations, individuals, processes in order to make sure that complainants, respondents, third parties, witnesses, other involved entities are treated fairly, compassionately throughout the entirety of the process. So we're going to go through relatively expediently just some of the many responsibilities that this person has been delegated. One of them is to know the policies inside and out. You have numerous newly adopted policies in the state of Louisiana and in the systems to which you are, within which you are employed. You need to know the uniform policy, that overarching umbrella policy on power-based violence and sexual misconduct, the Title IX grievance process. You should be familiar with the regulations themselves. Obviously, not all 2,036 some odd pages of commentary, but the regulations themselves are instructive Any related or additional institutional policies, again, to harken back to our plenary sessions this morning, individual campuses and institutions are permitted to supplement. The Title IX regulations don't cover every single aspect of an investigation or adjudication. And so where your individual campus customizes or supplements with additional policies, you should know those backward and forward to be able to shepherd the process thoroughly and efficiently from beginning to end. You should be able to know and oversee the procedures that are used to investigate and resolve Title IX reports and complaints, as well as those reports and complaints that come in through the power-based violence policy. So not only the policy, but the procedures, the nuts and bolts. How does it work? Who do you need to talk to? From whom do you need to gather information? To whom do you need to provide information? When and where does that information come from? And in what mechanism, through what method does it need to be disseminated? You are also responsible for coordinating the implementation and administration of the grievance procedures, like we said, from cradle to grave, educating the entirety of your campus community on how to file a complaint, conducting the investigation, overseeing the investigation rather, working with law enforcement and other related entities when necessary, and ensuring prompt and appropriate resources to complaints, including fair and equitable grievance procedures. Again, the entirety of the process needs to be overseen, coordinated, and shepherded by the Title IX coordinator. And then we'll continue going on through, sort of beginning to end what is to be expected of you. Evaluating requests for confidentiality, the Title IX coordinator is often and pretty generally in the best position to evaluate requests for confidentiality within the context of your institution, your individual campus's responsibility to provide safe, non-discriminatory educational environments for all of your students and for the greater campus community. The Title IX coordinator is also responsible for monitoring the outcomes of complaints involving power-based violence, that large overarching term that includes numerous categories of conduct, only one of which is that narrowly defined regulatory definition of sexual harassment. The entirety of the power-based violence scheme and structure is also efficiently housed within the Title IX coordinator. This individual provides and facilitates regular training, technical assistance if needed, related to investigations and adjudications, to be able to ensure that not only you, but the individuals with whom you work are familiar with your policies, with your procedures, with how things work, when and where their responsibilities come into play. This person may also be in charge of developing the programs, the training modules, assemblies on issues related to Title IX to make sure that all members of your campus community are aware of their rights, of their obligations, of the logistics of this process if they ever happen to be involved in it. We spent a lot of time this morning talking about the responsibility of the Title IX coordinator to implement supportive measures promptly, immediately, to make sure that a complainant retains equal access to your school's programs and activities. The implementation of these supportive measures also helps to protect that complainant, if necessary, once you learn of an allegation of power-based violence. Those supportive measures, like we said, we discussed them this morning. We will continue to discuss them this afternoon, but that immediate action item is housed, the responsibility for implementing that immediate action item is housed within the Title IX coordinator. Often that coordinator is a complainant's first point of contact, their first introduction to the Title IX process, and those supportive measures can help set the tone to ensure that our students and our employees feel safe and supported as they embark on the Title IX or power-based violence adjudication processes. That coordinator is also responsible for determining whether those supportive measures may need to be extended to campus-wide remedies, perhaps increased monitoring, right? We talked about the increase of security, campus security escort services, campus-wide protection measures in locations in which power-based violence is reported to occur. Maybe you need to increase or supplement education and prevention efforts campus-wide. Maybe that includes targeted populations. Maybe it includes the entirety of your campus community. But again, the entirety of the Title IX process, whether it occurs under the regulatory scheme or the uniform policy, is housed within that Title IX coordinator position.
This is a heavy duty position that you got yourselves into with significant and seemingly never ending responsibilities.
So at the beginning of the process, the receipt of a formal complaint, one of the first actual tangible responsibilities of a Title IX coordinator is to provide notice of the allegations to involved parties. So once you receive a formal complaint, a recipient, generally through the Title IX coordinator, has to provide the known parties with written notice of several different aspects of what's going to happen, including the contents of the allegations, what is alleged to have happened, when, where, as much information as you can provide in order to make sure that parties are adequately able to prepare. You have to provide those parties, whoever is known to be involved, with written notice of the institution's formal grievance procedures, right? These procedures should be readily available on the landing page, perhaps, of your Title IX website. But it's important, again, the theme of clear, effective communication to make sure that individuals involved in the Title IX or power-based violence processes know what lies ahead of them so that they're able to prepare, able to mount a defense if necessary, and that we're able to maintain the integrity of the entirety of the process. You also should provide parties with notice that there may be code of conduct provisions that prohibit making knowingly false statements or submitting knowingly false information during the pendency of the grievance process. Again, this intersects with the provision or the prohibition on retaliation, but it is important to note that you are still able to discipline participants in this process for lying during that process. Knowingly making false statements is still actionable under an institution's code of conduct provisions. Again, just fleshing out what some of that information that's required of you to provide to the parties might consist of. Sufficient details include, but may not necessarily be limited to, the identities of the parties involved. That might certainly help an individual mount a defense, begin gathering evidence, to know who is alleged to have been involved. The conduct, right? If you're operating through this narrowly defined, statutorily codified definition of sexual harassment, we only have those three categories of conduct that meet that definition. It's important that you explain to the alleged respondent what conduct it is that they engaged in that allegedly violates Section 106.30. You also must provide them, if you're aware of it, with the date and location. Again, we need to be as specific as possible so that we allow parties involved to begin gathering evidence and being able to maintain, again, that integrity of the process, clear, effective communication, making sure that people know what it is that they're accused of, the context in which it occurred, what the process itself looked like. You also must provide the parties with notice that they may have an advisor, somebody that is able to accompany them to meetings, to intake interviews, to every stage of the formal grievance process. That advisor may be an attorney, it may not be an attorney. It could be a parent, it could be a roommate. There is no requirement that a student or an employee accept this opportunity. They are permitted to attend meetings, to attend interviews, to go through the process to a certain point on their own. But if they elect to have an advisor, that advisor must be permitted to accompany them to all percolations of that grievance proceeding. You cannot limit the presence of an advisor. You cannot limit the identity of an advisor. You can, however, at least through the investigation process, limit the participation of an advisor. This means that you can, for all intents and purposes, require that an advisor, up until the point of a hearing, serve as a sort of potted plant, right? As long as those restrictions apply equally and equitably to all involved parties, and as long as you don't restrict a party's opportunity to have an advisor present. So again, it bears repeating now. I'm sure we're into double digits in terms of opportunities to discuss with you the importance of supportive measures, but it really does bear repeating. It is an important concept. The regulations spend a significant amount of text and words and commentary on the importance of supportive measures. And it's part of an institution's obligation to respond to allegations of sexual harassment equitably. You must provide supportive measures defined as non-disciplinary, non-punitive, and individualized services without charge to both the complainant and the respondent. You must at least offer them to all involved parties with or without a formal complaint. You must do it before and after and during. The supportive measures is another responsibility of the Title IX coordinator and the institution as a whole that simply cannot be abrogated. So those measures, supportive measures, are designed to, as we've said a couple of times now, restore, preserve equal access without unreasonably burdening the other party. Again, non-disciplinary, non-punitive, because the section on the formal grievance procedure 10645 prohibits the imposition of disciplinary or punitive measures without going through all of the hoops associated with a formal grievance procedure. Supportive measures are designed to protect student and employee safety, the safety of a campus community, to deter sexual harassment as a whole. Again, their purpose is to preserve equal access to the core tenet of an educational institution, to provide equitable access to schools, programs, and activities. Now, supportive measures might also include many measures that you've already been imposing. The important thing, however, to know is that failure to implement or to offer these supportive measures as required may constitute deliberate indifference under the Title IX regulations. That failure to adhere to this important prescribed metric might cause significant issues for the institution if you deviate from the procedures. So we've provided to you, there's this listed in the policy as well as in the regulations, a non-exhaustive list of what may constitute supportive measures. Again, they're intended to be individualized. So this list is not a one-size-fits-all. Not every complainant or every respondent will request or would even benefit from the imposition of each of these supportive measures. The individualized nature of them means that it's the responsibility of the Title IX coordinator to effectively communicate with the parties to determine which, if any, supportive measures would be most beneficial to them. They may include counseling, the extension of deadlines, the extension of course-related adjustments, transferring from one section of a biology lecture to another. Again, modifying work schedules, class schedules to permit parties to avoid seeing potentially triggering individuals, covering potentially triggering course material. It might involve the provision of campus security escorts, right, to permit people to walk or to be accompanied from dormitories to classroom buildings to parking lots to athletics facilities. It might include at this point mutual no contact orders. Again, those should not be one-sided at this point. They should be mutual if a no contact order is imposed. They might include changes in work or housing locations, particularly for allegations of sexual harassment that occurred in a dormitory. It might be a great idea to move one of those parties to a different floor, to a different building, to a different room, to ensure that those individuals don't come into any more contact with each other than is necessary until the process has played all the way through. They might elevate as far as to include leaves of absence. If parties, be they complainants or respondents, are simply unable to participate in your institution's proceedings at this point, it might be that they are simply unable to attend class, that they're unable to teach a class, that they're unable to serve as a TA, or whatever else their obligations might be. A leave of absence might be an appropriate supportive measure, again, depending on the individualized nature of each set of allegations. They might include any other similar measures. Again, this is not an exhaustive list. It should serve mainly as a jumping off point. And again, it is the responsibility of the Title IX coordinator to speak with all involved parties to determine which, if any, of these supportive measures might be appropriate, and then to make sure that they are implemented effectively. So upon the receipt of a formal complaint, the Title IX coordinator has several early action items that they have to comply with. Right, the Title IX coordinator should have an initial conversation with the complainant in order to, again, discuss these supportive measures, to tailor them, if any, to what that complainant may need at this time. To consider the complainant's wishes, this should be a two-way conversation. Supportive measures are designed to ensure protection of students, employees, involved parties, and it shouldn't be an edict or a set of measures handed down on the authority of the Title IX coordinator. It should be a two-way conversation, making sure that those supportive measures are as tailored and as individualized as they possibly can be. You should also explain to that complainant the process for filing a formal complaint if he or she or they wish to file one. Those detailed discussions are absolutely important. They can serve to help, begin the process of tone setting, expectation setting, making sure that complainants in particular understand the process that may or may not lay ahead of them. So in response to a formal complaint under the Title IX regulations, your institutions must follow the grievance procedure that complies with Section 106.45 of the nearly 2,000 pages of Title IX regulations and commentary. However, with or without a formal complaint, you must respond in a way that is not deliberately indifferent. That general duty continues and percolates throughout any process that you follow, regardless of whether it's a formal grievance process under the Title IX regulations or not. Your response to sexual misconduct, power-based violence must not be deliberately indifferent. And again, that is a relatively high bar. The Department of Education, federal courts generally find that there must be some egregious mistakes in order to find an institution to have been deliberately indifferent. But the best way to ensure that your institution is protected is to follow the explicit rulebook that the Department of Education has given us in this 106.45 formal grievance process. So again, the Title IX coordinator, after we get through the percolation of the process, is also responsible for the effective implementation of any remedies. Right, so these can be one-sided. They do not have to be non-disciplinary, meaning that they can in fact be disciplinary in nature. They can burden the respondent upon the determination of responsibility, but the Title IX coordinator's responsibility does not end with that determination. The effective implementation of remedies is also well within your wheelhouse, which might mean that for a particular case, your involvement may extend years, right? If a complainant alleges sexual harassment his or her or their freshman year, it may continue on until the point that that individual leaves your campus, until your jurisdiction over a respondent who has graduated ends. But again, from soup to nuts, cradle to grave, pick your metaphor. There is no point during this process at which a Title IX coordinator relinquishes that coordination responsibility.
Okay, so we have been going for about an hour. I'm going to suggest that we just take a quick 5-minute comfort break. I've got 2:21 on my watch. If we can come back at 2:26.
1:26.
I'm sorry, I'm on Atlanta time. That's where I am. Come back at 1:26. Thank you, Lexi. And we will pick back up with the next portion of this presentation.
Thanks, everyone.
Screen share again.
Mhm.
All right, welcome back, everyone. I hope everyone took their few minutes to stretch and walk around and whatever, and is ready for the back half of this breakout session. So Lexi spent a good bit of time talking about the really comprehensive role of the Title IX coordinator to truly coordinate every part of this process. We also want to talk about the investigative process with a little bit more granularity as well. The Title IX, sexual misconduct and power-based violence, these investigations are a balancing act, right? You are protecting your campus, you are protecting your students, but you also have this truth-seeking function that can lead to some uncomfortable interactions at times, but ultimately your role is to determine what happened so you can keep students safe, you can respond appropriately as an institution. And part of that balancing act involves conducting a thorough and fair investigation to help your institution determine what really happened and how it needs to respond. So Title IX investigations have a lot of purposes. Certainly, we want to gather pertinent facts and organize them in a presentable way. We want this investigation process to help inform the ultimate determination of whether or not the alleged conduct occurred. Now, that's not to say that the investigator is going to make that determination, but the acts of the investigator, the facts that they gather will certainly help inform that determination. The investigation should help inform if the conduct occurred, what kind of action the school should take to end sexual violence or sexual harassment or power-based violence and eliminate a hostile environment for its students and prevent its reoccurrence. Again, the investigator himself or herself is not going to make all these determinations, but the facts that they gather are going to be critical to informing those judgments. Good investigations also foster confidence in the school's vision and policies. When your campus community sees you living out your stated ideals of prompt, fair, equitable investigations, that generates confidence in the school's commitment to those ideals. Good investigations also bolster the concept of fair treatment. Not everyone is going to like the process. Not everyone is going to like the outcome. But if they feel like there is a process in place that is held to and adhered to with fidelity, that gives the correct amount of respect and deference and process to people on an equitable basis, that's going to help promote those kinds of ideals campus-wide. A good investigation also, of course, minimizes your school's risk of potential exposure to legal claims. At the end of the day, not only is this sort of a moral imperative to address and stop and prevent sexual harassment and power-based violence, it's also a legal requirement as well. So a good investigation is going to help you demonstrate, if it comes right down to it, that you did what you were supposed to do, that your institution acted the way it was supposed to act, and that you afforded your students and your campus community the rights to which they were entitled under law. And finally, a good investigation is going to greatly increase your institution's ability to successfully defend against a Title IX related claim that can arise. Keep in mind, folks can go through this Title IX grievance process on your campus and then turn around and file a federal lawsuit. And it happens just about every day, it seems like. And a good, thorough investigation is going to be your school's best defense against those Title IX claims, should they arise. Your investigations need to be equitable to the people involved. And an equitable investigation of a Title IX complaint requires a trained investigator with the ability to analyze and document the available evidence to support reliable decisions. At the end of the day, your investigation that you conduct is going to help inform a decision maker and guide that decision maker or panel of decision makers to the ultimate decision and remedies. An equitable investigation requires a trained investigator who can objectively evaluate the credibility of parties and witnesses. You're not going to be making credibility determinations as an investigator, but the facts that you gather are going to inform those credibility determinations that are made in a decision-making process. Trained investigators are able to synthesize available evidence, including both inculpatory and exculpatory evidence, and take into account the unique and complex circumstances of each case. You're not going to do the same thing as part of an investigation every single time. There is not a formula, there is not a checklist, there's no rote kind of investigation. Each investigation is going to be guided by the unique circumstances of the case, and it will be your responsibility to rely on your good judgment as investigators to ferret out the facts that you need to ferret out so you have a good, comprehensive investigative report. Some things you might want to consider as you sketch out your investigative plan is the nature of the allegations. Some may be much more sensitive than others. Some may be, behind closed doors where there aren't a lot of eyewitnesses or maybe even any eyewitnesses. So you're going to be looking at some tangential and circumstantial evidence. You'll want to consider the age of the student or students involved. Is this a freshman who is fresh to your campus? Are these seniors? Are these graduate students? You want to consider the size and the administrative structure of your institution, state or local legal requirements, including mandatory reporting requirements for schools that work with minors. You may have some minors on your college campuses who are freshmen. My nephew started college when he was 17 and just graduated when he's 20. He's about to move and get a job, but he can't buy a drink. But you may have minors on your campuses, so you'll want to keep those state level reporting requirements in mind. And also, of course, lessons from past experience. Every investigation is a learning experience and a learning opportunity. So you will build your best practice muscles as you do this more and keep those best practices of what works and jettison what may have presented some difficulty. Now, Title IX investigations are not criminal investigations, and we need to be very mindful to keep that top of mind for us and also keep that top of mind for the parties involved as well. When investigating an incident of alleged sexual violence for Title IX purposes, to the extent possible, an institution should coordinate with any ongoing school or criminal investigations related to the incident. The last thing an institution wants to do is compromise a criminal investigation of a potential crime. Certainly, we want to coordinate and not interfere with that. So how do you coordinate? Institutions should consider whether information can be shared amongst the investigators so that alleged victims and witnesses are not unnecessarily required to give multiple statements about a traumatic event. It is difficult enough to be questioned once about a traumatic event. Repeated questioning can lead to re-traumatization. It can also, as we know from investigations involving child abuse and the emerging consensus there, that being less than completely careful about how questions are asked can influence the kind of information you get. So asking a question as few times as possible to get the truth that you need is the way to go. So you're not repeating and going back and possibly compromising your factual pattern. Now, if your investigation includes forensic evidence, and it very well may, there may be a rape kit involved, there may be some other kind of physical evidence. It could be helpful for your institution to consult with local or campus law enforcement for a forensic expert to ensure that evidence is correctly interpreted by school officials while remaining mindful of FERPA requirements and exceptions. Now, as being on a college campus in your institutions, you have ready access to all kinds of experts in your faculty. You don't just want to go to the nearest expert. You want to make sure that this person is qualified to do what you're asking that person to do, and that you're being mindful of FERPA requirements and also maybe not exposing a student's very sensitive private information to another person on that campus who may interact with the student in a different kind of, capacity. And remember, your state law does require you to enter into an MOU with your local law enforcement and your DA and your campus law enforcement as well. And that MOU is a good opportunity, and development of that MOU is a very good opportunity to have a good, robust, multi-organizational, cross-functional conversation about how you can coordinate with law enforcement when you're dealing with these kinds of complaints. So no one's stepping on each other's toes. Everyone's pulling their oars in the same direction. If I use that metaphor correctly, I'm not sure I did. But basically, everyone's pulling in the same direction. Everyone's working to the same end, and no one's compromising each other. Now let's compare and contrast our Title IX investigations versus our criminal investigations. Title IX investigations are mandatory. When you get a formal complaint, you have to investigate. There is no discretion to not investigate. Criminal investigations are discretionary, and we know that local law enforcement can decline to investigate things for all kinds of reasons that make sense in the context of the criminal justice system that might not make sense in the context of college discipline. Title IX investigations are intended to determine whether an individual violated Title IX. Title IX is not a criminal statute. It is a civil law. Criminal investigations, however, are intended to determine whether an individual committed a crime and violated criminal law. Sometimes a Title IX violation is also a crime. Sexual assault is a crime. Rape is a crime. Domestic violence is a crime. But not every Title IX violation is going to rise to the level of a criminal violation as well. With a Title IX investigation, the possibility of incarceration or even arrest is impossible. They will never end that way. Really, the worst thing you can do to a student is expel them. In a criminal investigation, and that's terrible, that's a big penalty. But it pales in comparison to incarceration. And a criminal investigation, while a criminal investigation cannot result in expulsion, it can subject an individual to incarceration or criminal penalties. Sometimes you will have concurrent investigations going, and there will be times when the criminal investigation is terminated without arrest or conviction. That does not affect your Title IX obligations. Because Title IX is not a criminal statute, you are still obligated to complete the investigation and adjudicatory process, even when a parallel criminal investigation is terminated. Criminal investigations invoke certain constitutional protections, such as the right to counsel, the right to a speedy trial, the right to a jury trial, the right against self-incrimination, the right to confrontation, all of these constitutional and state law protections as well. Those protections don't exist in your Title IX context. The only protections that exist in a Title IX context are those that are spelled out specifically in the federal regulations and your Title IX grievance process. And finally, the Title IX investigation process has a very different standard of evidence. You will be using either the preponderance of the evidence standard, sometimes referred to as 50% plus a feather, or the clear and convincing evidence standard, which is a little bit higher than a preponderance standard. Criminal investigations, meanwhile, will always use the beyond a reasonable doubt standard. That is the highest legal standard in the law, is a much higher standard that you are going to be applying in the Title IX context. Ultimately, your role as an investigator is to uncover facts. Specifically to uncover facts related to the allegations of sexual misconduct by gathering documents and other materials, interviewing witnesses, and working with third parties, sometimes law enforcement when necessary, but ultimately what you are doing is uncovering facts. The characteristics of a good Title IX investigator you see before you. They're experienced, they are trained. This is part of that training as well. You are impartial. You don't come with preconceived notions or prejudgments about what happened or what didn't, or what tends to happen or what doesn't tend to happen. You are professionals. You are dealing with students who are young, but they are still adults and are to be treated with respect and professionalism at all times. You have good judgment. You know when to push, where to push, when to pull back in order to elicit those facts to fulfill that truth-seeking function that we have. You have the ability to competently testify in court proceedings if needed. There may be a parallel criminal investigation that turns into criminal charges and turns into a criminal trial. And some of the facts that you gathered in some of your activities as an investigator may be very relevant to that criminal proceeding, and you may be called to testify. You may also be called to testify in a live hearing in a Title IX matter as well. So that's an important skill for you to have. Good Title IX investigators are neutral. They do not favor women over men or men over women. They don't privilege complainants over respondents or vice versa. They come, like we said, with as much of a blank slate as is possible for any human. Good investigators search for facts, not opinions or beliefs. It is very tempting and very easy to form opinions based on all of those good facts that you gather, yet your role is not to cross over into the opinion or belief category or even recommendation category, but just to gather a robust set of relevant facts. Good investigators also build rapport with interviewees, complainants, respondents, and witnesses. Excuse me. I'm sure you all would agree, and it has been your experience, that it is much more likely that you will get good, useful, truthful information once you've built rapport to with the person that you're talking with. And in light of that truth-seeking function, you have the ability to build that kind of rapport, even in very uncomfortable and sort of inherently adversarial conversations. Now, these are inherently adversarial conversations that a lot of people just don't want to have. And it is not unusual for parties or witnesses to be less than professional, less than cooperative. And you as good investigators have the skill set to be prepared to professionally handle those kinds of situations and handle those kinds of difficult conversations that will inevitably occur during the course of a Title IX investigation. Now, of course, the investigation is conducted by the investigator designated by the Title IX coordinator. And an investigation can include lots of components depending on the circumstances of the case before you. Certainly, you want to conduct substantive interviews of the complainant or the respondent. You want to talk to them and hear what they have to say. You also want to, if there are any identified witnesses, you'll want to talk with them as well and get their statements and hear what they have to say. Sometimes there are parallel investigations happening with a law enforcement agency. So if possible, and if they will let you, you will want to take a look at law enforcement investigation documents. If there's a police report, it may be that a law enforcement investigation has already been conducted, concluded, with no further action taken by that law enforcement agency. But if you can get their records in their file, that can be certainly relevant information. Reviewing relevant student files may be relevant for you. Gathering, examining other documents like texts or emails. I don't think kids email anymore. I think they all text. Text, social media, other kinds of evidence. The scope of your investigation is very much going to be driven by, first, the complaint allegations themselves. And then second, as you gather evidence, that will inform your next steps about the scope and type of the investigation that you're going to be conducting. You know, neither the investigator nor the Title IX coordinator make any recommendations or credibility determinations. So this is where we all have to exercise some real self-restraint. Even if we know someone is just being untruthful to our faces, or we have a strong opinion about how this investigation should be decided, we've got to keep that to ourselves. Investigators are strictly fact gatherers and reporters. And importantly, investigators should not filter information that might be necessary to a decision maker's eventual review. You give the decision maker all of the relevant facts for their consideration. That decision maker will then review and decide disputes of facts. That decision maker will look at that beautiful packet of information that you put together and determine the weight of evidence and what is more credible and what is not, what is relevant and what is not. Now, the investigation packet itself is not evidence, but rather gives you a foundation to understand what the case is about. And it gives the decision maker the foundation to understand the universe of information that might be out there. Your investigative packet is so critical. And if you've done a good, thorough, fair investigation, those facts are going to speak for themselves. And you won't have to make credibility recommendations or determinations. The facts are going to tell the story that needs to be told. Again, you don't want to filter anything. You want to be inclusive, include all of that relevant information, but the facts and the story will emerge. And once you have turned over that investigative packet to the decision maker, just to give you a preview of what this information is going to be used for, the decision maker is going to look at all this and they're going to start making those kinds of determinations. They're going to factor all that in. That's going to inform and inflect their ultimate decision. There will be a live hearing, and ultimately, if a witness presents evidence at a hearing that contradicts material that they presented in the hearing packet that you reported as part of your investigative file, decision makers will rely on the evidence they heard. But if there are contradictory stories, that may inflect credibility determinations. Credibility determinations are within the province of decision makers, and that's why it's so important that you gather as many facts as humanly possible that's relevant, because if there's something else that emerges at a hearing, that in and of itself is an important fact for a decision maker to know. Now, the burden to investigate is on the institution. It is not on the complainant. It's not on the respondent to defend herself or himself. It is always on the institution. And we also need to ensure that the burden of proof and the burden of gathering evidence sufficient to reach a determination regarding responsibility rests on us and not the parties. Now, the one exception to that is medical records. If a party wants us to see their medical records, it is their responsibility to let us see them and make sure that they understand that that becomes part of an investigative file that will be viewable to the other party. We also have to provide an equal opportunity for the parties to present witnesses, including fact and expert witnesses and other inculpatory and exculpatory evidence. So we need to make sure that the parties understand if there are witnesses that they think have relevant information, they need to know that they have the right and opportunity to identify those witnesses. If they have evidence that they believe shows that the other party is guilty or shows that they are not guilty or responsible or not responsible, they need to know that they have the right and opportunity to present that kind of evidence, and we will include it in our investigative file. Additionally, we can't impose any gag orders. We can't restrict the party's ability to discuss the case and gather evidence. I want to spend a little bit of time talking about trauma-informed practices. The commentary to the Title IX regulations does reference trauma-informed practices in a very oblique kind of way. The regulations are explicitly not designed to prevent sexual misconduct. They are only designed to address complaints of sexual harassment as defined under Title IX. Nothing stops, the regs, however, do say nothing stops an institution from adopting prevention efforts, and nothing stops an institution from adopting trauma-informed practices so long as those trauma-informed practices are consistent with the regulations. So let's talk about where trauma-informed practices, or kind of a common belief about trauma-informed practices, might bump up against the requirements of the regulations. Trauma-informed interactions, that term has become part of the vernacular for a lot of people. And when that happens, the meaning of the term can get a little stretchier than practitioners and experts might use it. But ultimately, it's a set of beliefs, and it's based on the neurobiology of trauma and the impact it has on the brain, that tells us that when people undergo a trauma, the neurobiological effects of that on the brain may lead to certain things like gaps in memory or temporal confusion, or a response in the moment that doesn't make sense to us sitting in in the cold light of day. And that those gaps in memories, that temporal confusion, that kind of behavior can make sense as a trauma response. The danger is to assume that every complainant has undergone a trauma, because that is an assumption that every complainant is the victim of sexual harassment, which is another way of saying you've prejudged the case and you found someone responsible before you've gathered the facts. That being said, there's nothing that prevents you from using trauma-informed practices in how you approach your interactions with both complainants and respondents in a way that is wholly consistent with building rapport and wholly consistent with your ultimate truth-seeking function in these kinds of situations. Some tips on using trauma-informed techniques to evaluate evidence. At the beginning, ultimately what you're trying to do is you're trying to get the facts, you're trying to build rapport, you're trying to put people at ease so they are candid and complete with you. So at the beginning of your interview, you can say something like, I'm going to ask a lot of questions to clarify, just to let them know you're asking that not because you disbelieve them, not because you're trying to catch them in something, but simply because you need to have the details. And if there's a detail that you think you're missing, that you're going to very politely, very gently, and very respectfully ask for it, because it may not occur to them that that is something that might be important, but you don't want to leave anything off that would be important. Now, if possible, we certainly recommend allowing a party to give an uninterrupted narrative and go back and ask questions later. Sometimes, it's understandable that this is hard to talk about if someone has experienced something like this, or is being accused of something like this. That can also be hard to talk about. So you want to let them say what they have to say, get it all out, and then go back and fill in any gaps that might exist. Avoid asking why questions. They can sound and come across as accusatory. They can sound disbelieving. And that's the last thing you want to do. You certainly don't want to leave a party with an impression that you've already suspected them of being untruthful, or that you've determined that they are in fact untruthful. Asking about sensory information can sometimes lead to details that you may need that may help fill in those gaps in memory that a trauma response might create. So asking a question like, when this happened, what did you see? Do you remember hearing anything? Are there any images or sounds or smells that keep coming back to you? It is not unusual in the context of a trauma response to have a certain sensation or a certain sound or a certain smell just take incredible prominence, and have that sensation or smell or sound trigger memories and help individuals fill in gaps. You'll also want to listen for course of conduct, power, and control. How does this person describe themselves in their narrative? How are they positioning themselves as a person of agency or a person without agency in this narrative? That can often also be a trauma response as well. It's also important for you as investigators to consider broadening your time horizon. What other information can you gather that might help the decision makers determine whether the parties had the capacity to make knowing and deliberate choices, i.e., did they have the capacity to provide knowing voluntary consent to whatever happened? Trauma leads to nonlinear thinking, or it can lead to nonlinear thinking, which means puzzle pieces of the narrative of the memory may be missing. In addition, it is not unheard of that power-based violence and sexual harassment is accompanied by the consumption of alcohol and or drugs. And consumption of alcohol or drugs can also lead to omissions from memory as well. And your job is to help the decision maker by gathering all relevant facts to determine the most likely set of events, recognizing that the pieces of the puzzle may be missing. They may not fit together perfectly. It may not all make sense at first view. But if you bring all the puzzle pieces together, whether they're disjointed or not, that informs the decision maker about what ultimately happened. Now, it's not a knock on a witness's credibility if they simply don't recall or can't recall certain details. I could not tell you what I had for breakfast yesterday, for instance, and there's a lot of literature out there about the fallibility of even eyewitness testimony. When something escalated is happening, people actually aren't all that great at remembering all the details of what they see. It's not a knock on a witness's credibility if they try to fill in the gaps. We fill in gaps of our memory all the time. We rarely remember things that happened, even escalated things that happened perfectly on our first run through. We run through it again, and then we remember bits of the puzzle and fill them in later. But it is your job to try to figure out what factually happened and assess consent. Consent is the seed of this. If there is consent, we do not have sexual harassment. So you must gather the facts that can inform that question. Often there is not going to be corroborating evidence on the question of consent. What happened in a room between two people, and they are often the only two people in that room, who may have been under the influence as well of alcohol or drugs, is an extraordinarily difficult thing. And that's why it is so important for you as investigators to use these kinds of trauma-informed techniques to get to truth, to seek out lots of facts and lots of information, to seek out truth, so you can ultimately help that decision maker find out what really happened and what that remedy should be, if any. And when you're gathering information about consent, remember that consent to engage in a sexual activity needs to exist from the beginning to the end of each instance of that sexual activity. People do have the right to change their minds and say stop in the middle of something, and that is a withdrawal of consent. Consent is demonstrated through mutually understandable words or actions that clearly indicate a willingness to engage in a specific sexual activity. Now, I don't mean that there needs to be a verbal, yes, you can kiss me, yes, you can hold my hand, but both of the people involved need to have a mutual understanding that they're both saying yes to this activity. Silence alone, without actions evidencing permission, does not demonstrate consent. Acquiescing is not consent. Consent needs to be affirmative, it needs to be knowing, it needs to be voluntary, and it needs to be communicated. To give consent, of course, a person needs to be of legal age. As we said, assent does not constitute consent if it's obtained through coercion or from an individual that the respondent knew or should have known was incapacitated. Incapacitated people, by definition, do not have the capacity to offer knowing, voluntary, affirmative consent. And the responsibility of obtaining consent rests with the person initiating the sexual activity. And use of alcohol or drugs does not diminish that responsibility. Consent to engage in sexual activity, like I said a minute ago, it can be withdrawn by any person at any time, including the person that started it. That person can change their mind too. And at that point, continuation of sexual activity is happening without consent of both parties involved. Once withdrawal of consent has been expressed, sexual activity's got to stop. And consent is automatically withdrawn by a person who is no longer capable of giving consent. So if a person says yes in the beginning and then passes out in the middle, that is a withdrawal of consent because they are no longer able to provide ongoing consent to the activity. Also, please know that a current or previous consensual dating or sexual relationship between the parties does not by itself mean consent to a specific sexual activity. You can say yes one day, and that's good for one day, or that one act, and that doesn't carry over to anything else. To assess consent, you use the same techniques we just discussed for gauging credibility and evidence. Typically, again, there's not going to be a lot of corroborating evidence. These kinds of activities tend to happen behind closed doors, not in front of any other people. So the question of consent is a hard one, but it's a critical foundational one. Now, an individual is considered to be incapacitated if, by reason of their mental or physical condition, that person is manifestly unable to make a knowing or deliberate choice to engage in sexual activity. Sometimes incapacitation is easy to see, sometimes it's not. So individuals who are asleep, unresponsive, or unconscious, those people are pretty obviously incapacitated and unable to give knowing, voluntary, affirmative consent to sexual activity. There are other indicators of incapacitation as well. They could include the inability to communicate coherently, an inability to dress or undress without assistance, an inability to walk without assistance, loss of coordination, vomiting, inability to perform physical or cognitive tasks, slurred speech. I don't want you to take this to mean that, for instance, slurred speech automatically means someone is incapacitated. Someone can have a little bit too much to drink and have slurred speech, but still be able to consent. But it is certainly a factor. And obviously, the more inebriated a person is, the more critical and I guess scrutinized the question should be whether that person actually had the capacity to consent at all. Ultimately, incapacitation is the inability to make a knowing and deliberate choice to engage in sexual activity. Like we said, it can result from mental disability, sleep, an involuntary physical restraint, the intentional or unintentional taking of alcohol and or other drugs. And we know that that sort of slipping of drugs to people, that unfortunately happens in real life. Whether someone is incapacitated is typically judged from the perspective of an objectively reasonable person. There's that reasonable person, that mythical creature in the law. But this is where some common sense really does come into play, and the facts surrounding it do come into play. And when there is a question of incapacitation, that is when there is an ability for the decision maker to evaluate some corroborating evidence. So facts such as how many drinks did this person have over what period of time is going to be relevant. Could this person form words and speak? That's going to be relevant. that may inform the ultimate decision about whether this person was incapacitated and even had the ability to offer consent in the first place. What food did that person eat that day? Did they have a bunch of beers on an empty stomach? That might hit differently than if you had a beer after a sandwich. How does the consumption of alcohol or drugs typically affect that person, or a person of that similar body size? What did the witnesses see before or after the alleged incident? Who can discuss the level of each party's inebriation or incapacitation? Ultimately, it's about not having the ability to make informed, rational judgments. So the other behavior that occurs around the time of the alleged incident can certainly inform whether or not that person was incapacitated. You'll start with whether there was evidence of sexual harassment as defined in the policy. That's sort of your jurisdictional seat as to whether you're even talking about sexual harassment or perhaps power-based violence under the umbrella policy. And your next question is whether there was affirmative consent. If you know there was not affirmative consent, you have a policy violation. If there is affirmative consent, you keep going. And if you don't know, then you move on to whether or not there was incapacitation. If the person was not capable of giving consent, you have a policy violation. If that person was capable of giving consent and gave consent, you don't have a policy violation. And if you don't know, you need to come to a decision or at least gather enough facts to allow a decision maker to come to the decision under the outline standard of either preponderance of the evidence or clear and convincing evidence, whichever your institution has adopted.
So then jumping back into some of the nuts and bolts of the investigation process, in response to a formal complaint, the investigation necessarily includes providing the parties with opportunities to review the evidence before that evidence is in effect codified in the form of an investigative report. You have to provide both or all involved parties an equal opportunity to inspect, to review any evidence that you gather as part of your investigation. Before you complete your investigative report that will then be submitted to the decision maker and will contribute to the ultimate determination of responsibility or non-responsibility, you have to submit that evidence to the parties and to their advisors if they have any, and you have to give them a period of 10 days with which to respond. You have to also, as an investigator, consider their written responses before you complete your final investigative report and hand it off to the next section of adjudication. This fundamental fairness, opportunity for the involvement of due process, permitting parties to review evidence, to respond to that evidence, goes to that central tenet, that core.
I don't know if you guys can hear this, but our office
Things are
is very
happening.
close to a fire station and there is clearly a fire. We apologize.
Somebody is having a bad day. The ability to respond to that evidence, the opportunity to be heard, to correct any factual errors in the narrative, to present additional evidence in order to maintain the integrity of the investigative process and the ultimate adjudicatory process. We have to make sure that the investigative report and the file itself is complete. And sometimes the parties are the best mechanism through which you can verify the completeness of your investigative file. So by giving the individuals, the entities involved, an opportunity to review your entire file, you are able to provide them with the knowledge and the faith and fidelity in the process. So again, we have attempted to hammer home the idea that it is not your responsibility or your obligation as an investigator to make any conclusions, to recommend sanctions, to recommend an ultimate determination of responsibility, but it is your job and it is an obligation of yours in constructing your investigative report to fairly and completely summarize and analyze the relevant facts that you determine that you uncover that are provided to you throughout the course of your investigation. You should include references as applicable to supporting documentation, to statements, to screenshots, to Facebook messages, to emails in the event that those are what your parties use to communicate. You should, again, make sure that you're providing that opportunity to your parties to review each other's statements. They should be provided with a written summary of any other information. Again, making sure that your parties believe that the process is fair, that they have been given an opportunity to prepare for an adjudication in whatever form that may take, fairly and effectively. Those parties are granted 5 calendar days after they receive that summary of any additional statements. The investigator should then use that feedback provided to them by the parties to address any factual inaccuracies, any misunderstandings, to fill in any gaps. Again, the parties may oftentimes be the best resource to ensure the completeness and the thoroughness of your investigative report and of the file that you ultimately hand off to the decision maker. That investigative report should again provide a summary of your impressions, should provide context for the evidence, but it should under no circumstances make or recommend a final determination about whether a violation of the power-based violence policy occurred, whether a Title IX sexual harassment allegation was substantiated. You should reserve that decision and the decision of any sanctions, any remedies to the appropriate decision maker. It's important here to make sure that you do a gut check before you submit this investigative report to check for any biases, whether they are explicit or implicit biases. We need to again make sure that we are able to maintain the integrity, the fidelity of this process. This report is nothing more than a factual recitation with appropriate context. This is not a place in which you should make, reach, recommend any additional conclusions. Again, as Nina said, a thorough, comprehensive investigative report will allow the facts to speak for themselves and will position the adjudicator, the panel, the hearing officer, whoever your ultimate decision maker is, will position them well to be able to internalize the data that you've uncovered, the evidence that you have presented, and allow the facts to speak for themselves. So again, we covered this very briefly in this morning's plenary session, but at any point prior to the ultimate determination of responsibility, we provide the parties with a series of off-ramps to exit the process entirely or partially. And one of those off-ramps takes the form of informal resolution. Now, the regulations don't give a lot of color, a lot of structure to what this informal resolution process must look like, and that's intentional. It might look like a mediation, it might look like an arbitration, it might look like something else altogether. But the sort of underlying point of an informal resolution process is to empower the parties to construct an adjudicative process that works for them, to empower individuals to speak their truth, to carve out potential remedies or sanctions that they feel are appropriate. This informal process can take place in lieu of the formal grievance process, which we know includes some pretty significant procedural requirements, a live hearing, the requirement for cross-examination. That monumental process may be daunting, may be intimidating, and may not be appropriate for the resolution of some certain categories of misconduct. However, before you engage in an informal resolution process, you have to make sure that all involved parties are apprised of their rights, that they have the right to withdraw from an informal resolution process at any time and would simply revert back to the point of the formal grievance process at which it was paused. You must obtain both parties' voluntary and written consent to engage in an informal process and to implement any of those informal measures. Again, the point of an informal process is not to mandate or to dictate any person's involvement in the process, but is instead intended to empower those individuals. And so making sure that they're aware of what they have signed up for is critical here. Again, we are involving remedies-based, non-judicial processes designed to eliminate or address potential power-based violence. This is coming straight from the uniform policy, implementing concepts of restorative justice, making sure that the parties feel that the process was tailored and appropriate to them. However, your institutions, your campuses should not compel face-to-face confrontation between the parties. Again, this might look more like a mediation with the parties located in separate rooms and a mediator traveling in between them. You should also not compel participation in any particular form of informal resolution. The campuses and individual campus communities have a lot of discretion, and the parties should be able to participate in the exercise of that discretion to craft informal processes that work for them. The only required caveat is that the regulations are explicitly clear in that informal resolution processes are simply not allowed to adjudicate formal complaints of sexual harassment alleging that an employee has sexually harassed a student. I think we can understand why that prohibition exists. It's that, in maintaining the integrity of the process requires an investigation into power-based dynamics, and that an informal resolution process involving an employee and a student necessarily violate that potential for power imbalance. And we want to make sure to stick to the straight and narrow when we investigate and adjudicate instances of power-based violence, sexual harassment involving such power differentials. So to harken back to some of our original slides, again, the Title IX coordinator maintains responsibility for the process throughout and after the adjudication is complete. You are at the center of the process, regardless of how long it takes to work its way from beginning to end, from inception to conclusion, and throughout after that duration, throughout that conclusion as well. The Title IX coordinator maintains responsibility for a number of action items, including selecting the decision makers, providing the requisite notice to the parties, communicating clearly with those parties again to make sure that they are kept well apprised of the logistics of the process, of the expectations placed upon them, and making sure that they're well aware of what is in wait for them. The Title IX coordinator is responsible for coordinating witness lists, adjudicative logistics, when that adjudication will take place, where, in what building, in what room. Will all of the parties and witnesses be located in the same room? Do you need to arrange for a transcript or an audio or a video recording of that process? What method will testimony be given in? You must provide the investigative report and the comprehensive investigative file to the decision maker and to the parties, or at least oversee that handoff. You must ensure the fidelity of the process throughout the adjudication. Ensure that rape shield protections are properly understood and implemented. Making sure to obtain, to explain and ensure that privileges are recognized and respected. To ensure that cross-examination at a live hearing is conducted only by a party's advisor and never by a party personally. To ensure that relevancy determinations are made accurately and are made in real time. To ensure that the sufficiency of the decision and its component parts, conducting at this conclusion stage a gut check, making sure that the process has been followed with fidelity in all of its component parts, providing notice of that decision to the parties, understanding that in almost all instances, at least one of them might be displeased with that outcome. It remains your responsibility to implement any of the sanctions or the remedies recommended or enacted by the decision maker. That includes the continuation or the perhaps addition of supportive measures. For example, implementing no contact orders. It also includes ensuring the long-term adherence to the decision maker's ultimate decision. Again, that might extend past a single semester or an academic year. Your responsibility continues as long as the case presents itself in front of you. That also may require conducting periodic check-ins to make sure that you're updating and providing individualized supportive measures as necessary. Also, in the event of an appeal, it is your responsibility as Title IX coordinator to determine whether sanctions are going to be stayed pending that appeal. And then also coordinating and ensuring the propriety of the appeal in the event that one does happen. Again, we have hit repeatedly on the importance of this prohibition on retaliation. It is found in your Board of Regents uniform policy on power-based violence. It is explicitly included in the Title IX regulations. And the overarching implication is that retaliation in any and all of its forms is expressly prohibited at any point during the investigation, the adjudication, and that resulting time frame. Again, retaliation cannot occur on the part of a school, and it cannot be conducted by any individual person. That includes the parties themselves. Again, retaliation can take a couple of different forms. Again, this list is meant to provide you some guideposts, but is certainly not exhaustive. Retaliation might consist of intimidation, of threats, of coercion, of outright discrimination for engaging in protected activity under Title IX or is implementing regulations. This means that, again, you cannot, as that first bullet point indicates, retaliate against an individual for participating or refusing to participate in any manner in a Title IX formal grievance procedure. That means that you cannot, as we mentioned earlier, terminate supportive measures for a complainant who decides that they no longer wish to participate or corroborate or assist in that investigation. It also means that you cannot retaliate against a respondent simply by virtue of the fact that that person is named as a respondent. Like we mentioned earlier, you cannot charge an individual with a code of conduct or an overarching policy violation simply to avoid some of the onerous procedural requirements of the formal Title IX grievance process. You cannot charge somebody with assault or with an academic violation to get to the end to impose a sanction if the reality of the allegation necessitates making sure that you go step by step through the formal grievance process. There are some nuances to that retaliation prohibition. For example, that individuals maintain the rights afforded to them under the Constitution and the First Amendment's right to free speech. This comes up a lot and will continue to come up in the context of social media. Again, we are in no way, shape, or form wish to mute people's ability to speak their truth, to share their narrative, but there is a certain point at which that online conduct may cross the line into retaliation, in which case institutions and Title IX coordinators need to make sure that they are implementing appropriate corrective action if and when applicable. And again, the regulations explicitly carve out that you may punish an individual for lying during an investigation. The simple fact that an individual is participating in a Title IX proceeding does not insulate them from all violations under your institution's code of conduct. Making a materially false statement in bad faith, lying outright in the course of a grievance proceeding and punishing that person for that activity does not constitute retaliation. However, we have to make sure that a determination regarding responsibility alone does not serve as the basis for concluding that a party lied. Retaliation is also prohibited, as we said, under the uniform policy. The Board of Regents and all institutions expressly prohibit retaliation against anyone who engages in protective conduct or protected conduct. And that includes reporting in good faith what they believe to constitute power-based violence. Again, we want to encourage these reports and encourage the fidelity of the investigative process. And so making sure that we are protecting and facilitating that report process is critically important. You cannot retaliate against anyone who cooperates with an investigation or a proceeding under that overarching umbrella policy, nor can you retaliate against anyone who opposes conduct that they believe violates that policy. Again, knowing or understanding that an individual who knowingly makes a false accusation will be subject to an investigation. They may be subject to disciplinary action, and that disciplinary action could be quite severe. It could involve termination for employees, expulsion for students. Again, we want to make sure that we maintain the fidelity of the process so that the parties involved, even if they disagree with the ultimate outcome, can walk away with an understanding and an internalized belief that they have been heard, that the process was fair, that the process was equitable. There's a carve out in the uniform policy, section 6, that an individual who reports power-based violence and has perpetrated or assisted in the perpetration of that violence is still subject to an investigation and potential sanctions. That reporting, telling on yourself does not insulate you from the potential for investigation and ultimate determination regarding responsibility and the imposition of any disciplinary sanctions. So after a determination regarding responsibility is handed down, again, there are instances in which a party may wish to appeal that ultimate decision, the outcome of that adjudicative process. The regulations set out a couple of mandatory grounds for that appeal. We discussed them briefly this morning. We're going to dive a little deeper into them this afternoon. The first one is that there was a procedural irregularity that affected the outcome of the matter. That materiality threshold is important. Not every single procedural irregularity, especially with a regulatory scheme as complicated and involved as this one, will give rise to the basis for a permissible appeal. But as Title IX coordinators and investigators and advisors and others involved in this process, it's important, again, to make sure that we have followed the explicit rule books granted to us by the Department of Education and by your respective institutions. You must follow the rules in order to ensure that an outcome is fair and is equitable. The second bullet point provides that new evidence that wasn't reasonably available at the time a determination was made that might have affected the outcome of the matter. Again, the imposition of that materiality threshold, simply uncovering that somebody drove a red Volkswagen Beetle as opposed to a blue one, may or may not affect the outcome of the matter. However, we have to make that determination in order to see whether we've reached that materiality threshold. But again, conducting a full and a thorough investigation the first go round limits the opportunity for parties to allege that there was new evidence that has suddenly come to light. And then finally, the mandatory ground for appeal as codified in the regs provides that an individual must have an institution must grant an appeal if there is an allegation that the Title IX coordinator, the investigator, the decision maker, or frankly, any other individual involved in that process had a conflict of interest or a bias, whether that's for categories of humans as complainants or respondents, or against a particular individual involved in that process. Again, the same materiality threshold. This person didn't like me because I graded them harshly isn't necessarily responsive to that outcome of the matter determination, but again, making sure that you as Title IX coordinators, as investigators, and then the other breakout session as decision makers uphold those core basic philosophies of equal and equitable treatment, decreases the likelihood that a party will, at the conclusion of a matter, allege impropriety, that you have engaged in inherent, implicit, explicit bias, or that you harbored a conflict of interest. And then your institutions, respectively, can offer appeals on additional grounds as long as those bases for appeal are available equally to both parties. So we have covered a significant amount of ground today, both this morning and this afternoon. I understand that there's likely some questions that have come in to the chat over the last couple of hours. We will turn off this PowerPoint and see how many of those we can tackle.
And I believe that they are dropping all of the questions in the Q&A function. Am I right about that?
Yeah, that looks like it.
Okay,
All right.
we got it. All right. Okay, first question. What if agencies required will not sign MOUs or cooperate? Example, the DA's office. Well, you know, I continue to point to a state law that requires this kind of cooperation. It is not unheard of. I will share with you in my own experience, trying to get cooperation from law enforcement agencies to meet all kinds of student needs is sometimes a very difficult hill to climb. My suggestion to you is that you do the best you can, that you document your efforts to reach an agreement and an MOU with these offices, that you don't just have one outreach, but you continue to have continued outreach to those offices and develop your MOUs with as many law enforcement and community partners as you can. And if there's an outlier, there's an outlier. Just make sure it's not because of your institution's failure to do outreach, failure to communicate, and failure to try. Okay, our second question, I'm going to give this one to you, Lexi. Semi-annual report, does this follow Clery, meaning stats from last year? Oops, I'm sorry. Or are these current stats in the last 6 months, considering this will not match what is required by federal law and will be confusing to persons looking to make informed decisions on whether to attend the university as the purpose of Clery? Okay, I will take that one.
I was going to say, I think that might be a you question.
I understand. So
they're separate and distinct.
Right. So there's a Clery Act reporting requirement, and now there is another state law required reporting requirement. Those cycles may not be the same. They may not have all of the same information. And my best advice to you is to follow the requirements of both the Clery Act and your state statute as reflected in the uniform policy. I understand that this kind of information is concerning to parents and it might be confusing to parents. I also understand that if we're really doing a good job of encouraging reporting instances of power-based violence, the reports are not going to look real great for a little while because the numbers are going to go way up. And it is very difficult to explain to a parent or to an interested student that that doesn't mean your campus is less safe than the other campus. It means that your campus has this culture of reporting and encouraging reports so it can be addressed. So there's going to be an initial spike before it goes down as a result of your prevention efforts and your campus culture efforts. But my advice to you is to make sure that you are complying with both of those reporting requirements.
And we gotta fly through. Okay. The next one I think is also yours. It's on the transcript withholding and notation policy.
Sure.
And how that comports with the regulations requirement to treat parties equally and
Sure.
avoid the implementation of punitive measures.
Mm-hmm. So can you speak to how Title IX coordinators in case, wait, am I
Yeah,
the right question?
Yes, you are, but just,
Okay.
I would start here.
Okay.
Right here, negotiate.
Negotiating the transcript withholding notating requirement in state law and the uniform policy and the focus of Title IX regs to treat both parties equally, maintain a presumption of not responsible, and not implement punitive measures before a finding of responsibility. That is an excellent question. And again, my advice to you is to follow your state law. I do take the position that this is a safe harbor. There's not a lot of information on a transcript of a student who's been the subject of a complaint of power-based violence. All it says is administrative matter pending. I don't know that that rises to the level of being punitive. Like we said this morning, that could be anything from not paying your student activity fee on time to plagiarism, to going for a joyride on the campus golf cart. I don't know why that metaphor keeps sticking in my head. It does not disclose, or I don't believe unfairly provide unfair stigma to a student. I think those two things are compatible. And I will also share with you that transcript notation, withholding, and communication policy was the product of very rich and robust discussion because of that very point, with system council and Title IX coordinators across the system and other representatives across the 4 systems as well. And we worked very hard to co-create something that we felt adhered to the spirit of Title IX, but also the spirit of the state statute, that just put a receiving institution on notice, hey, something happened, can't tell you what unless you call us. And I believe that those two things are compatible. Okay. 4, can communications be recorded either video or just audio? And if you're referring to the live hearing component, the requirement under Title IX is that a recording be made. So if you just want to do audio, that's fine. However, in your virtual hearing space, if you are doing a virtual hearing, you need to have real-time access for everyone to see and hear testimony. So you need to have video access during your virtual hearing. But if you, for your archived recording, it can just be audio. You just want to make sure that there aren't any quality issues and you really can hear it. Okay, what about asking witnesses not to discuss the case with others? You can ask, you can always ask. And I don't see anything wrong with asking and letting them know, look, you know, people, potential witnesses talking to each other can compromise fact gathering, can compromise our truth-seeking function, but they don't have to. They don't have to comply with you. They still have First Amendment rights to talk about what they want to talk about, except that they can't release someone else's confidential information that they learned during the course of an investigation. Okay, our next question: if one party presents new evidence, does it need to be shared with the other party to review? Title IX regs are pretty clear that everybody gets to see everything. So all your statements, all your evidence, the short answer, yes, everything needs to be disclosed to the other party. Is the Title IX coordinator expected to intervene in the live hearing if, for instance, relevancy of a question is not determined or determined incorrectly? I do not believe, and Lexi, feel free to jump in if you feel differently. I don't believe Title IX coordinators need to attend hearings. Decision makers receive training on these very types of questions. Our best advice to you is frankly to have your system counsel available or your institution counsel available to assist with those kinds of relevancy determinations. They can get really complicated. You know, lawyers and judges disagree about what's relevant all the time. If any of you watch lawyer shows, they're not that far from the truth when the lawyers get to arguing before the judge. So our advice is to have system or institution counsel available to your decision makers if it's anticipated that things would get complex.
But it also may be advisable to ensure that the Title IX coordinator is present at that hearing. For example, they might be called as a witness to testify to sort of what procedure has been followed. So even though, no, I think to answer your question directly, they are not expected to intervene, just to ensure that the process plays out as intended to the best of their ability. Again, we are asking Title IX coordinators to wear a bunch of different hats. The truth of the matter is they cannot wear every hat in the world at every moment of an adjudication process.
Right. After identifying a power-based violence case and moving it forward from formal complaint through adjudication, what is the role of the student conduct officer in relation to the Title IX director or coordinator? In other words, what are the roles of the two when dealing with power-based violence cases? So we're a little bit of a disadvantage in that we each institution is going to have different expectations for their individual student discipline offices. But the role of the Title IX coordinator is consistent across the board. They're coordinating. So if the rule is at your institution that the student conduct coordinator is in charge of monitoring suspensions or expulsions or restrictions or whatever for anything that isn't Title IX, but you're dealing with something that is Title IX or is power-based violence, your Title IX coordinator needs to coordinate with that person as well to ensure that that's happening. So they're working hand in hand, essentially. Let's see.
So that one.
Okay, that one we just answered. Can you speak to how?
We just answered that one
We
too.
just answered that one, sorry. In regard to holding joint interviews, I have had repeated comments that our campus police do not want to participate in this matter because if they learn about criminal activity, they will have to move forward with this, even when the student ultimately may not want to. How can we counterbalance this? So the question is about, does the institution want to have a joint meeting with local law enforcement or the campus police from the get-go, but campus law enforcement is resistant to doing that because they don't want to have to move forward? What you can consider doing is, well, I mean, first of all, I have sort of a foundational question about that because I'm aware of instances when law enforcement learns of a potential crime, but they choose not to pursue the case for whatever reason. But putting that aside, if campus law enforcement doesn't want to be involved, they don't want to be involved. The institution is not a law enforcement agency. The Title IX process is not a criminal justice process. The power-based violence process is not a criminal justice process. If they don't want to be involved, they don't need to be involved. That's their decision. But you as an institution need to go ahead and follow your process and do your thing under either the Title IX formal grievance process or your overarching umbrella power-based violence process and keep that process moving. Okay, there are conflicting, oops, I'm sorry. Okay, there's conflicting information as to investigating new complaints that are alleged to have occurred before the new regulations went into effect. Any guidance on the appropriate process to take? Lexi wants to take this one. I can tell.
I want to desperately. Yes, there is guidance. It comes straight from the Biden administration's Department of Education. They recently released, I think back in July, a pretty comprehensive question and answer document on how they intend to enforce the current Title IX regulatory scheme unless and until they decide to alter the final rule. And I will read to you directly from the mouth of Biden's Department of Education. The 2020 Title IX amendments took effect on August 14th, 2020, and are not retroactive. This means that a school must follow the requirements of the Title IX statute and the regulations that were in place at the time of the alleged incident. The 2020 amendments do not apply to alleged sexual harassment occurring before August 14th of 2020. This is true even if the school's response was on or after that date.
So there we go. A straight, bright line answer from the feds, which we like when we can get it.
Yes, we get it rarely, but we'll take it.
Our next question, when discussing retaliation provisions and prohibitions throughout the presentation, the providing false accusation or knowingly reporting penalty has provision, suspension or expulsion termination has been lumped. What is the relationship between the two, or should they be unlinked?
So there is a potential train of thought that says that because I have participated in any form in a Title IX proceeding, I am immune from any adverse action. That is incorrect. If you lie knowingly in a Title IX grievance procedure and are punished for it, that does not constitute retaliation. So it's a bit of a forward and backward thinking, and it helps to envision it as if somebody were going to levy a lawsuit against the institution for the way that the Title IX process played out. Their allegation will be retaliation. I received adverse treatment, even though I was participating in this protected group of activities. I was participating in this process, and I was assured that as a participant in that process, I would not be allowed to be retaliated against I was thereafter fired or expelled, I am calling retaliation. Lying, making a false statement with the intent to harm somebody, and being punished for that conduct does not constitute retaliation. The concepts are separate, but they are linked in the form that it might be a defense. Does that make sense?
Mhm. All right, so it's 3:45, so we have time for one final question. I apologize, we can't get to all of them. But our final question, is the 2015 Board of Regents Uniform Policy on Sexual Misconduct obsolete since the release of the Uniform Policy on Power-Based Violence / Sexual Misconduct? Yes. The new uniform policy was adopted last Monday. It is now in effect. It supersedes the prior policy.
Yeah, okay.
So I see that Commissioner Reed is going to be joining us for a closing in any minute now, and I certainly don't want to take any time away from her. Oh, we can say until 2:50. Okay, great. We'll take a few
So
more.
this one, I think it's an even, can a coordinator delegate one or two of his or her responsibilities to an assistant? Absolutely. The term Title IX coordinator includes the Title IX coordinator, his or her or themselves, as well as any properly trained and designated deputy Title IX coordinators. Again, there is a human aspect to what we are asking of this individual or group of individuals. However, all of the responsibilities must be delegated to someone. You cannot just simply say, it is too much, I can't handle it all. If you cannot delegate it to somebody else of appropriate authority, you've got to find a way to figure it out on your own. But there is no responsibility of a Title IX coordinator that simply can be left unfulfilled.
Okay. What about recording the interviews during the investigation process? So I have thoughts. A recording can become part of the pile of evidence that you have to trade with and provide to the other party. So you want to keep that in mind. You also want to keep in mind what the effect of recording might do to your interviewee's behavior. It may set an adversarial tone that may not be productive for you from the outset. You may want to spend some time building rapport with the interviewee first. There's certainly no prohibition against recording these interviews, but if you've recorded them, that becomes part of your investigative file that needs to be disclosed to the other party. Okay. I think we answered every question, did we?
This one.
Oh, I'm sorry. Okay, there is one more. Please provide clarification regarding the initial contact with the complainant section on pages 16 through 17 of the policy. There is the initial contact made via email typically, and then the meeting that occurs with a Title IX coordinator where the Title IX coordinator provides a large amount of detailed information. Is this section talking about both the initial email contact and the meeting with the Title IX coordinator? Let us go to that part of the policy and review it. I confess I've not committed every word to memory as yet. Okay. So to my mind, the way this needs to work is Title IX coordinator receives a report, reaches out to the complainant and says, hey, I need to schedule a meeting with you. I need to explain a lot of information with you. Let's just schedule. It is strictly logistical because you don't want to dump
Overwhelm
this kind of information and this amount of information via email to someone who is potentially the victim of power-based violence and who doesn't really know you yet. So make an initial reach out email just for logistics to set up a phone call, set up a Zoom, set up an in-person meeting or whatever, and that's where you can share the substantive information.
I think that is all of them.
Okay, well, it's 2:49, so we're
it.
doing great on timing. Thank you all very much. We really appreciate you staying for this, asking really great questions, being really engaged, and the work you do to keep our campuses safe.